validity arguments because of the prescribed page limits. A patent owner asserts additional claims. So if a patent owner asserts additional claims in district litigation, then you can file an additional petition. Now, the important thing is you have to be within your statute. So if you pass the statute, then you're time barred to make any additional petitions. Excuse me. Now, the PTAB has discretion to join the following petition with the original petition, as long as the following subsequent petition is filed within 1 month of the original proceeding. Okay. Oops. Okay. Now, one sec. Okay. Now, what's important in PTAB petitions is you must select the best argument. The PTAB will not allow redundant arguments. So if you have an anticipation argument which is difficult, go with the obviousness argument instead. Don't let the PTAB choose, because they might choose the weaker grounds, and then you're stuck with the weaker grounds when you might have a better argument for the other grounds. Also, it's important to use the best prior art in any PTAB petitions because of the estoppel considerations. For IPR and PGR, you're stopped from using any grounds which you used, not only that you used, but which you reasonably could have used. So you should have your best prior art available and use it in PTAB. Okay, just going to go a little fast here. Claim constructions, as we mentioned, there's a broader claim construction standard in PTAB, which is the broadest reasonable claim constructions in light of the specified standard. Patent issue, and the reason for this, one of the reasons is that the patent owners can amend their claims during the PTAB proceedings, whereas in district court, you cannot amend your claims, and a claim term is given the meaning that a term would have to a person of ordinary skill in the art at the time of the invention. Now, submitting expert declarations is very important to support proposed claim constructions. The patent challenger can do this at the original petition stage, and the expert declaration support is usually not available to the patent owner till he files a response after the PTAB Institute's review. You've got to be careful with having consistent statements in both the forum, because if you have conflicting statements, that could be very damaging for your case. Now, the PTAB is not bound by district court's claim construction. District courts are not bound by PTAB decisions, but because PTAB decisions, judges have specialized patent expertise, the district court judges may treat these decisions as persuasive. Now, discovery is an important factor here in PTAB. It's very limited in PTAB proceedings, and this is a huge discovery cost savings for petitioners compared to the very expensive discovery in district court litigations. There are two types of discovery in PTAB. One is routine and one is additional. The routine is any exhibit cited in a paper or in a testimony which is not otherwise publicly available or which has been served. The cross-examination of a declarant testimony is an important part of discovery. It usually makes up the largest portion of discovery. PTAB rarely allows live testimony at oral hearings, so cross-examination is often the only way to obtain further information from opposing experts. Additional discovery usually is given for good cause. And the PTAB looks at various factors, like the request must be clear, not overly burdensome. It should not be able to be figured out in other means. You can't use discovery requests to alter the procedures of the PTAB, and there has to be sound basis for asking for additional discovery. Now, the important thing is confidentiality of PTAB proceedings. Usually there's none. So most proceedings, most papers, most are filed in the PTAB are usually available to the public. You can, if there is a reason to seal, you file a motion, and it's only, the information is sealed only for good cause. Now, there's about 80% of PTAB proceedings have concurrent DC litigation going on. The important thing to remember is that you cannot get money damages in district court. You can only get it in district court, not in the PTAB. Advantages of moving early for a stay of district court litigation while the PTAB is going on. You save money because your discovery and other litigation costs will be delayed in the district court till the PTAB gets a resolution, and you minimize depositions of key personnel, like the 30B6 depositions, et cetera, in the district court litigation. So, okay. Now, the chances of stay of litigation after the petition has been filed, the district courts have a wide discretion to grant a stay in district court litigation while IPR is being handled in the PTAB. It also depends on the facts of the case, but there are some factors where you have a high chance of getting a stay, which is if you apply early for a stay in the district court litigation, in the district court litigation stage, or if the PTAB trial has been actually instituted. Remember, you have to apply to get it instituted. Almost 2/3 of these motions, even if the PTAB trial has not been instituted, are usually granted. The chances when you have less chance of getting a stay in district court litigation are if the district court litigation is at an advanced stage, like the claim construction stage is over, or if a decision is imminent, or if it's a multi-party patent case where only a subset of parties are requesting IPR because of concerns of inconsistent case management. The factors used for IPR for district courts to stay the district court litigations are usually they look at these 3-factor test, which is the stay of litigation, whether a stay will simplify issues in the district court case, whether a stay would increase undue prejudice to non-moving parties, or provide a clear tactical advantage to moving party. For the CBMR, it's been codified. These 3 factors are added to a 4th one, which says whether a stay or the denial thereof will reduce the burden of litigation on the parties and on the court. Now, the advantages of a PTAB trial: the burden of proof is lower, preponderance of evidence versus clear and convincing in district court. Technical expertise: PTAB judges have technical expertise. Claim terms are given the broadest possible interpretation. There's cost savings if the petitioner can stay co-pending district court litigation. There's less attorney's fees involved because you can stay the district court litigation, so you decrease your discovery costs, document production costs, document review costs, and there's less disruption to patents, to petitioner's business for complying with discovery obligations. The advantages, other advantages are settlement leverage, which is a very big one. Having a concurrent PTAB trial can greatly increase the settlement leverage of a petitioner in district court, even if you just file the PTAB petition. And the other advantage is for a petitioner is that these documents are public, so other infringers, so the patent owner is kind of concerned that they don't want these invalidity contentions being available to the public, which they will be after the PTAB trial is instituted. And the discovery costs are low. The risks are the estoppel risks, where for IPR and PGR, you're stopped from using any invalidity arguments which you raised or could have reasonably raised during the PTAB proceedings. The other risk is that these PTAB proceedings move very quickly, so you have to have your initial arguments well prepared and well presented in the beginning. And that's it.